The grand jury that was impaneled to meet on Thursdays to investigate the death of Kathleen Savio and the disappearance of Stacy Peterson returned a 2-count bill of indictment today, charging 2 counts of first-degree murder, one on the theory of intentionally killing, the second on knowingly doing an act that could cause great bodily harm. I appeared before Judge Daniel Rozak this afternoon and requested a bond in the amount of $20 million, which Judge Rozak granted without question. This is an extremely grave and serious matter, and I think that's reflected in the bond. He also signed a search warrant, which the state police executed this evening. The state police, during this 18-month period, have done a phenomenal job under a very difficult funding situation with their department, and but never once, when asked to do something, did they hesitate or in any way delay. And my office could not function without that kind of dedication from the investigators in the field. This case will be prosecuted in Will County. There may be a motion for a change of venue, so I'm going to be very careful here what I say. I've made every effort to make sure that our office and the state police have done nothing to prejudice any jurors that might be selected in this case, and we want to continue to adhere to that. I want to mention there is a law that was passed recently that was spurred by these cases. It's basically forfeiture by wrongdoing, where we're going to make a motion to admit statements made by Kathleen Savio in the trial. These would be admitted as substantive evidence as an exception to the hearsay rule. It's a significant step forward in the prosecution of these types of cases, and we look forward to the challenge. At this point, we'll take questions on a limited basis.
Jim, how confident are you that you have the evidence to put Drew Peterson away for Kathleen Savio's murder? After an
18-month investigation, nothing dictated our time frame. I know there was a lot of speculation in the news media that different people were going to drive us to do one thing or another. We moved when we felt that the time was appropriate, and that culminated in the 2-count bill of indictment that we obtained today. And we're very confident in our case.
Jim, the new law that was passed, do you think that helped further this investigation, this hearsay that was passed in Illinois?
Well, again, evidence that we've uncovered in the investigation, which previously might not have been admissible, we have the ability to have a hearing before the trial begins, and if we prove by a preponderance of the evidence that Drew Peterson killed or murdered Kathleen Savio, then the court can allow those statements in at the trial if the court finds that they're relevant and probative. And we believe that the statements that we have would meet that standard.
And Jim, what is it that you believe Drew Peterson did? How did Drew Peterson kill Kathleen Savio?
Again, I cannot go beyond the language that we used in the bill of indictment. In layman's terms, what is phrased there is drowning. But again, legally, we phrased it the way it was necessary to best prosecute this case. And you've got a copy of that before you.
But in layman's terms, can you sum up what it is you believe he did?
I can't speak to the facts of the case.
Is Drew Peterson the lone suspect in this case?
Pardon me?
Is he the lone suspect in Kathleen Savio's death?
He's the named defendant, and he's the defendant we're going to proceed to trial against.
But do you think he acted alone?
Does that mean they're significant? You mentioned that the statements might be significant by Kathleen Savio. Are there any specifics that you can give us about those statements?
I cannot.
Can you tell us what are those statements, or when? What are you talking about with the Kathleen Savio statement specifically? From where, when, what?
These would be statements made to third parties that previously have not been admissible in Will County courts, been ruled hearsay. And in essence, what you're basically allowing the victim of a violent crime to do is to testify from the grave. But it's not done without very serious protections for the defendant's rights. There has to be a hearing. The statements have to be reliable. They have to be probative and relevant. And the judge, if they don't find those factors to be in place, they won't allow the statements in. So we've got a tough road ahead of us, but we believe we can meet that burden.
Were his children